First of all, I would like to introduce our chair for the day, Mr. BP Singh, former chairman and in charge and technical member. I would now like to introduce our speaker, Ms. Pragya Chaturvedi, IP Attach, UK High Commission, New Delhi. I would now like to introduce the second speaker, Ms. Anvesha Kumar, Manager, Legal, Tata Medical and Diagnostic Private Limited. Now I would like to introduce the third speaker, Mr. Breedt. I hope I'm pronouncing it right, sir. Managing Director, Nielsen Book Data. Now I would like to go to our final speaker, Mr. Rahul Goel, partner, Anant Law. It's such a great pleasure for us to have you all today here. And now I would like to hand over the session to our chair, Mr. BP Singh, and I hope you take over from here, sir.
Thank you so much. Am I audible? Okay. Good afternoon, you all.
Yeah, I hope sir, you're audible. I hope everything is clear now. You're audible completely.
Okay. So welcome you all on board. And it's really my proud privilege to be here amongst you today. And what interaction we have in a couple of days. I believe that the session is going to be very lively. So the girl has introduced all of us. We have ourselves introduced through different social platforms. So the organizers of this program certainly deserves our commendation because they have chosen very nice topic. The topic for the day, and that's for our discussion, is monetization of intellectual assets. Here was one task people used to create, but they were not going up to commercial stage, and everything depends upon commerce these days. If you see the World Bank data on commercialization, I have seen, because I'm a student of patent, so I have just seen that what is the filing figures of the patents in about select few countries, about 7-8 countries, including UK as well as USA, other countries, Japan, China, etc. And saw that there is a huge gap between the expenditure which we make on using IP assets of somebody and the gain that we do for our indigenous IP assets, if such is there. We'll be discussing in the later parts of the discussion. But copyright also plays a vital role. And it will be our pleasure to hear you all. As we have so decided, let's first open the discussion, and then certainly we will come to the general conclusion, and our own discussion will open. So I'll request Pragya. Pragya, I believe that we have met sometimes in some seminar somewhere. Okay, so now you are representing your IP attaché at UK High Commission. So welcome you, and please share your views onto this burning topic of the day. Please, the floor is all yours. If you still desire, so Ms. Anvesha, please, you can go ahead.
Sure. Thank you for the introduction. And it's a great platform, I think, to basically come together and discuss about the IP issues and the monetization aspect of it, because to my belief, the entire the various acts within the IP has been made with an intent to commercialize and monetize and basically generate revenue out of it. I would rather more specifically talk here about the copyright aspect of IP, and would like to share my views about it. Considering I had a great stint within the media and advertising industry, and entertainment industry also. I would rather more concentrate on how basically the monetization of the IP happens within the media industry, because I think that's one of the sector where your copyright plays a very important role to talk of. And every like with every passing year, new things are keep on basically coming up and building up within that sector. So basically, to concentrate and just jumping onto the topic here regarding the monetization of IP within the media and entertainment industry, I would like to just give a brief background of how the business model works basically within these industries and how we cater the legal risk within it. So when I basically talk of monetization aspect, basically what happens as a producer of a film or as a production house of a film, we usually engage with these individual producers and get into a co-producer agreement whereby the content is bought by the producer, and we enter into sort of co-production agreements whereby the production company ensures that the IP, basically the copyright over the product, basically splits 50-50. However, the exploitation right totally comes to the production house, because production house has the expertise of monetizing it. How do we monetize this is basically on different platforms, putting those films within theaters, then putting it on OTT platforms, then putting up, selling those right to the music labels are the various means of monetizing it. So basically there are linear modes to monetize and there are non-linear modes to monetize also. One of the upcoming modes of monetization that is also coming is basically you can pick up those film characters that you have built in and put it in a gaming platform and create characters out of it. So this is one of the new trends that are coming up. I think this entire industry is expanding in such a large pace, even with NFTs coming up. I think the media industry is on a verge of making money out of the slightest IP that's come into their way. I would just give certain examples here to basically we can get an idea out of how the monetary aspect basically rolls into it. If as on date we are making a film, when you make a film, there are various rights attached to it. I'll just take an example of Andhadhun for that matter. Andhadhun was a Hindi language film which was made. As on date, you would see a remake version of Andhadhun also in a Tamil or a Telugu language. So basically, as a producer, if I've made a film, I'll ensure that I further basically pass on a piecemeal basis or sell, basically assign on a piecemeal basis all those right to different parties so that I can make money out of the product that I've made. In this situation, that's the film. That's basically the revenue part of it. As a production house, my intent is to basically bring in all the pieces, as an engage an actor, bring in the script, engage an author, engage a music composer who can give me the music on the films. Those are also all the aspects where I'm assembling the IP to create an entire package and then sell it off in the market. So it's a chain that actually follows. I think this is one of the aspects which needs to be looked into minutely when I talk of assembling all those IPs, because eventually as a performer, be it an actor, be it a singer, these all forms part of a performer within the Copyright Act. So the performer also comes with the moral rights. Performers have a special moral rights within the Copyright Act. So you have to, as a production house, we have to be very sensitive about those rights not being infringed, those rights being taken care of, and then eventually passing on, making an entire package and passing on to the different parties to monetize the entire IP. To my understanding, the entire media business and the production house is generating huge revenues as on date following this business model, whereby they would buy a content, package it in a certain fashion which is marketable. So it's an entire chain that follows. When I talk of basically regarding specifically now, if I talk of about the music industry out here, how does a music label, say suppose T Series or Saregama follows? There is a platform whereby they make their own content. However, there's a major platform whereby these production houses sell the entire music right to the music labels, and that's how they monetize, because the music label already know the means and channels to monetize it. They would basically engage, say, suppose with Sony to put it on those broadcasting platforms. They will engage with MTV, which is basically owned by Viacom 18, to put it on their platforms to monetize and make revenues out of those songs, which is basically an audiovisual clip here. How the chain follows is we have to be very critical that a performer or a music composer gets their royalty. So there are societies whereby they collect royalties and then pass it on to to basically the authors or the music composer. So that chain has to be followed, is something very important. So with every passing step, the way you try to expand your revenues for making revenue, you have to be very critical that you ensure that the route that you started off is not entangled in a chain whereby you are put in a spot whereby you haven't paid royalty on time, or you have basically breached the moral rights of the author or of a performer. So that's the chain that needs to be followed here. Other aspect that I would like to basically harp on is how the social media platforms, and how basically, for that matter, the subscription video on demand, which is Netflix, Amazon, is playing a major role in bringing those content to the general public. Because be it Amazon Prime, be it Netflix, be it all these OTT platforms, are basically subscription video on demand platforms mostly. And individual like us subscribe to it and have a very easy access to all those contents. So SWOT platform, as well as the TWOT platform, which is transactional video on demand, or AWOT platform, which is YouTube, actually is playing a major role for all these, for monetization and generating revenues for all these IP content. So when I talk of majorly content here, is basically whereby all the any artist is putting up anything on those platforms and getting revenue out of it. So my understanding is this entire sector is going is expanding drastically. It has a huge business and a huge future ahead. And we are in a, every day we are coming up with new ideas and new aspects to basically ensure that this aspect keeps on expanding. So like 10 years down the line, India wouldn't have thought of a platform whereby something like Netflix will be there, or something like Amazon Prime will be there. We used to basically, what we used to do is that we used to have those hard drives whereby I would download a movie and put it on a hard drive for my accessibility. Now the entire ball game has changed, and there are things which are upcoming every single day. So this is what we have seen within the media and entertainment industries. Apart from the broadcasting which you see on the television, things have changed and evolved a lot. And this is only because as an organization and as an individual also, who is an artist who wants to monetize the content they are creating, and as a media company who is acting as a platform. Media companies are acting as a platform, as a jump for all these individual artists who are creating content. So I think there is no limit to it, because we wouldn't have thought of an NFT, because right now MTV has released a couple of their NFTs and it's out in market, and it's priced amazingly well. So these are the things that are upcoming. These are the ways where you can monetize on your IP. And to what my understanding is, there will be still new business model and avenues that will keep on coming to it. So I think I would just put this on the platform, and would like to know your views about it regarding this aspect.
Thank you, Ms. Anvesha. You have been very informative. Yes, very true. Earlier, one thing was there was no awareness, and people, due to lack of awareness, you can say, if you see the music industry, if you see the film industry, there have been n number of cases of copywriting, copyrighted material being used in different languages. Some foreign films be dubbed here, some foreign songs exactly of the same music being played. Now the awareness has increased, and rightly you said that the packaging of all the rights, all the related rights of copyrights are yielding results in a better fashion. Thank you so much.
So thank you, Dr. Singh. Thank you to IRRO for having me here, and a very happy World Book and Copyright Day to everybody. Um, I would start by saying that while we are talking about intellectual assets, IP protection is vital. It is also one of the key pillars of the creative economy, which involves the publishing industry, and the creative economy in general is heavily reliant upon copyright. But IP is best used when it's commercialized, because that's how you can monetize your intellectual assets. Even the Minister of Commerce, Shri Piyush Goel, has noted recently that what we need in the country is an IP revolution for increased competitiveness and enhanced job creation. And commercialization is a major pillar in ensuring that. Um, I have in my role as UK's IP attaché to India, I have worked with the creative industries previously in supporting them in with their IP issues in India, and some of them were key copyright issues that the publishing industry has been facing. It has also been mentioned in the recent all party parliamentary group report in the UK. So we have been closely involved in working with the publishing industry in general. And I'm mentioning this because the theme is the World Book and Copyright Day. But since our panel discussion focuses on monetization of intellectual assets, I will speak generally about what the UK Intellectual Property Office has been doing or plans to do in the future to support businesses in commercializing their IP. So, generally, innovation is critical in tackling the UK's biggest challenges, including achieving the net zero transition, leveling up growth across the country, and achieving our ambitions as a global trading nation, and in ensuring economic recovery from the pandemic. So on that note, I would like to share the innovation strategy, which has been recently released by the UK government's Department of Business, Energy and Industry Strategy, which is the UK Intellectual Property Office's parent department. And then I'll speak about what we are doing at the IPO to support that innovation strategy, because IP is very much the underlying theme when we speak about innovation. So the innovation strategy has four pillars. Uh, One of them is unleashing business. So we want to support businesses who want to innovate and increase the annual public investment on research and development to around 22 billion pounds. Second pillar of the innovation strategy is focused on people. So we want to make the UK the most exciting place for innovation talent. The third pillar is institutions and places. So we want to make, as I said earlier, we want to make UK the best place to ensure research and development. And the fourth pillar is missions and technologies. So we want to stimulate innovation to tackle major challenges faced by the UK and the world, and to drive capability in key technology. So when we look at the above pillars, IP is a key player in creating the right environment to meet these challenges. And because an effective IP system provides the much needed confidence to businesses, creators, and investors that their ideas will be protected and they can monetize them, and they can ensure that they get a return for their work. So the IPO's corporate plan includes a program of work that supports the UK government's general focus on innovation, and that includes developing an IP innovation passport and an IP in finance strategy, and also a framework which links IP to stages in the business cycle. Um, Other than that, our innovation strategy, the UK IPO's international strategy, sets out a multi-step program, the concrete steps that we are going to take to support the base innovation strategy. And I can expand upon that later. I will not take too much time right now. But I also want to share the IP for business online tools that the UK IPO has to support businesses in protection and commercialization of their IP. So one of them is the online training tool that we have to help businesses understand how IP works and how it can be protected using different types of IP, help them understand how to manage their IP and how to best leverage it to protect their investments and products. We have the IP Health Check initiative, which helps businesses by providing them a tailored confidential report based on a series of simple questions, which includes a list of recommended action points for businesses to protect and exploit their IP, and guidance on how to put each recommendation into practice. We also have the B2B online toolkit, which provides advice and guidance to businesses who wish to collaborate with other businesses. And that involves preparing for initial discussions, negotiating contracts, and best practices, and resolving any issues that might arise from collaboration. So that enables businesses to recognize and consider how IP is protected and utilized before and during collaborations, and how it is owned, managed, and licensed afterwards. Other than that, we have the business life cycle framework. It has been developed to support entrepreneurs and businesses to understand and manage their IP at every stage of their business life cycle. So this framework provides information, guidance, and support for businesses through the stages of pre-start, startup, and then commercializing their IP, growing and scaling up. And finally, we also provide face-to-face training to businesses, which can help them developing a detailed understanding of intellectual property and how it relates to their business. And it also helps them in developing some practical skills that they can apply to a business environment. So that's it in a nutshell, the UK government and UK IPO's current and future initiatives, which can support businesses in making sure that they get the most out of their IP. In India also, we have collaborated previously with different industry stakeholders on IP commercialization. And going forward, our priority, one of our priorities will be to strengthen our collaboration with the Government of India through our mutual work plan on intellectual property under the MOU that the two countries have on IP. So I'll stop there, and yeah, happy to take any further questions or to expand upon what I've mentioned.
Thank you, Ms. Pragya. You have narrated the whole sort of initiative of UK government, UK IPO, right from the creation, the protection, and commercialization, their strategy, how they are developing. And now it has been very informative. Let's have, if we manage time in later, then we'll have certainly some further more information. Now, I think in UK it is noon time. Mr. Andre Breedt, it's noon time there in UK.
It is.
So good noon to you, and I welcome you on this platform, and will be more than eager to listen your views onto this aspect, which is very burning, because you create anything minus commercialization, minus monetization, the business model is not going to grow. So to create and to grow business, the monetization is very much imperative. So we'd like certainly to listen your views. The floor is Mr. Andre Breedt.
Thank you very much. And I'd also like to thank the organizers for putting together such an extensive set of events today. I was really quite impressed with it, and thanks for asking me to speak. So first of all, just a little bit of background. Unlike, I think, all the other experts here, I'm not an IP expert. I'm a market research and a metadata expert, so I'm finding all the other things very interesting. So my expertise is from a very different angle, but I think very relevant when you talk about monetization. While I was sort of doing my preparation for this session, I reread a few IP papers, and the number one step to any effective monetization of any intellectual property assets, whether they are vested in law or through contract, is knowing that you have them. And I think that is probably one of the first and most important steps to monetizing and making sure that the assets are well monetized. There's very low transparency across markets and within markets of actually which assets exist, and then also who is the current owner of the assets. And if we focus on the book market itself, it's also really important that the standardization or the understanding of all the different parts of the assets. When our first speaker spoke about the importance of sort of being able to monetize assets in films and in games and in music, knowing which parts of what asset are owned by who in what market is almost the underlying base layer. It is something that we as a business work on, but it's also something that is just a thing I'd like to highlight as a challenge for all the participants within these markets, and especially if we're talking about, you know, the opportunities across languages. And if you look at a market like India, the importance of knowing who owns the rights in which language for which market is an easy question to answer. It's an easy question to ask. It's a really difficult question to answer, and sort of building those frameworks, A, legal framework, but then B, a database or a list or an agreed standardized way of identifying the owners of IP is hugely important. Then most of the work that we do, other than on like the metadata side, is then on the measurement end. So we measure book markets in many countries, including India. We focus on measuring the consumer book market rather than the educational, though we also measure that but through other ways. The consumer market we measure through the actual EPOS sort of data out of a physical till or out of an internet retailer's database. So that's large data sets that we have. And I think here the thing that's interesting about intellectual property monetization, or if you're talking about a sustainable business, often publishers of all kinds will be heavily focused on new product because that's where their marketing effort is focused, that's where authors are focused, and that's where the current zeitgeist or like what people are interested in is really focused. But really the sustainability of a business is heavily reliant on its ability to sell its backlist. And I think it's important then to actually subdivide its backlist into long backlist, like mid backlist and recent backlist, because they all have to be treated differently and they're all very important. And I think a lot more discussion or thinking about how the different stages of the backlist, especially if we're talking in the book market, are then monetized, is how you have a sustainable and profitable business. Otherwise, publishers end up chasing the next big hit sort of eternally without ever really effectively having a sustainable mid-list. And that sustainable mid-list of not long backlist titles, but not new titles is often where most of the profitability comes from. And then often also the financial cycles often don't actually look at it properly because the accounting is focused on the most recent year, not like a 3-year valuation of an asset, which brings me to my next one, which isn't our area of expertise. But again, if you do the reading, valuing an intellectual property asset is also something that is very difficult because you can value the opportunity and you can value the current sales. And here I think how people look at an asset over a longer period of time is very important because it then lets you see its sort of true value, and that can help to also unlock financing for businesses if they're able to say, I have this set of assets which I can monetize over a 3 or a 5-year period, rather than only focusing on the big hits within the next cycle. Then there is there's also a need, I think, to always remember that when we talk about monetization, ultimately we're talking about some sort of consumer demand. And understanding what that consumer demand is really important, because otherwise you're sort of reverse engineering it. You're going, hey, people, you should want this thing because I think you should want it, not what would you like, and I will go and find the things that you like. So understanding understanding consumer demand and matching intellectual property then to that demand is, I think, the right way around. Otherwise, we can get stuck on either elitism or snobbishness, or just pure, I have these assets, but you should want to buy them. That's not how consumers work. And as we found through the pandemic, and as I think we keep on finding, the consumer is also all of us, and the consumer is a complex, multifaceted person. They're not some sort of like monolith who all like one thing, and we should just sell them that one thing. So having an understanding of how our end consumers are sort of changing in their habits and really matching the existing intellectual property right or objects or sort of creative works, to the consumer is our job. And I think those are really the main things that I wanted to say. So I'm not going to say much more. I'm happy to participate in the Q&A later on, but those were the points I wanted to make. Thank you.
Thank you, Mr. Andrew. This is, in fact, see, here on this count, I believe that organizers needs our appreciation, because they have chosen the diverse panel, particularly to show that, because monetization is not, a singular job. It has to be done in a chain fashion. The creation, the protection, and the role that you are defined for yourself is the one which we are looking for, because finally the intellectual asset has to go to market. The valuation is one which is very, very important. We never know that what creation has been done, how much value it will have. So you are the actual person in field who will be evaluating those things and going further. So thank you so much for your nice information which you shared with us. Now I'll focus on to Mr. Rahul, who is waiting for long. So Mr. Rahul Goel, your views, please. Thank you.
Thank you so much, Dr. Singh, for this. Good afternoon and namaste to all.
Namaskar.
So essentially the topic is monetization of assets. Now really when you talk about monetization of assets, it is very important to first create a value around that asset. And as what Andre rightly said, it is the first step is to understand whether you actually have an IP asset with you or not. Identifying that asset is the key job. I'm a practitioner, so we work with a lot of startups and we work and we advise them on a lot of these issues. Now, what I have generally seen when you're looking at creation of an IP asset, especially as a startup entity, you first don't really know whether the asset that you have would fall in that category, whether that asset could be categorized into a patent, trademark, copyright, or any other IP asset form. So one part is to possibly identify that, get it registered to start with. And when people look at registration, they normally go for the IP registration. The simplest one would be the trademark registration or a copyright registration. Now, the advice that I generally give to people that, in terms of the long-term business sustainability, it is important first to understand and identify and look at the structuring of the IP asset. The strategy that you would want to have in your business, who are the IP, would be the starting point. And then the second part would be to go and get the asset registered. The third important aspect is, once you have achieved the strategy and the registration, the third important aspect is which is not predominantly a practice in India, is that people don't disclose their IP assets in their books of accounts. That is one big challenge that they face at a later stage. Now you have an IP, you go, you get it registered as a copyright or a patent or a trademark. You have a strategy in place that after 5 years, I would license it or sell it. But that asset is not visible in your books of accounts. Now, after 5 years, the challenge would be that what would be the valuation around that IP asset? You have no valuation which is there. You would sell the asset, you would earn an income, the tax department would come and would put a capital gains tax on you. And then you are wondering that, I have not strategized it properly and now I'm paying tax on the asset. So strategy, protection, and then disclosure of that IP asset is the first starting point for monetization of the asset at any point in time in future. What we have also seen essentially is that when you're looking at disclosures of the IP assets, people are generally worried about the payments which would go to the tax department because now it becomes an asset. But largely in terms of, if you're looking at a long-term strategy, This is an investment that you are making at the initial stage, and the benefits would be reaped at a later stage when you are monetizing that IP asset. That's the one important key that has to be kept in mind. When we talk about monetization of assets, IP assets or intellectual assets, there are generally two forms, especially which are implemented. One, you sell it directly, sale of the IP asset, or the second would be the licensing of the IP asset. Now, sale of an IP asset has its own implications. It's rather a simpler set of rules which would apply to a sale of an IP asset. Obviously, in a sale kind of a scenario, you would also look at capital gains if the transaction is happening, and the volume is big. In case of a licensing, the set of rules would be a little different. Now, why I'm looking at licensing as one of the key features here is that because the market, the way it is currently operating, you would see that the licensing structure is more predominantly adopted by a lot of companies, with a large, medium, or startups. And therefore, licensing regime is one of the very important regime which has to be looked into while you're looking at monetization of the IP assets in some form. What we have also seen is that in terms of licensing, there are certain aspects which, as a company, we do not keep in mind. Now, when you look at a licensing of an intellectual assets, there are two things which are essentially there. One is the brand and the goodwill associated with the brand. And two, the goodwill associated with the product itself. So, for example, and this is one of the live cases that we dealt in the past. For example, you have Foster's as a beer. Foster's is a brand which is registered in, or which originated in Australia. Everybody, when they talk about Foster's, they think about Foster's as an Australian beer brand. Nobody talks about Foster's as an Indian brand. Foster's has presence in India. They are selling in India. Now, at some point in time, Foster's wanted to, divest their Indian business. As soon as the divestment happened, the tax department came and asked for the capital gains tax. The challenge here is whether the IP assets were stationed in India or were they stationed in Australia. The situs of the IP became an important aspect to examine in this kind of a scenario. So therefore, when you're looking at these kind of situations, because when you're looking at monetization at any stage in your life, you would also come across similar situations. So when you're looking at monetization in similar situations, what you would have to look into is the situs of your IP. Where does it stay? Second important part would be that even if it's a licensing kind of a situation, you would also look into the aspect of the goodwill which is associated with the brand. And I think this is generally an accepted rule under the law, that especially in a trademark kind of a scenario, if the licensing is being done, the benefits that accrue out of the licensing or the usage of the product accrue to the licensor or the trademark owner. So therefore, in similar kind of a situation like Foster's, the benefit in terms of the goodwill that is generated because of the brand Foster's would accrue to the company which is based in Australia, which originally licensed the brand Foster's to an Indian company. The second aspect here is that what would happen to the beer which is in that bottle? Who would gain out of that goodwill? So the product, the goodwill associated with the product and not the brand here, would accrue locally, and that would go to the licensee. So these are the aspects which are a little complicated, but at any point in time, if a person is looking at monetization and long-term sustainability in terms of the business and monetization of the IP assets on a long-term basis, I think these are the key aspects which have to be kept in mind while structuring your business from the very beginning. IP is one of the key important factors for structuring of businesses. Now, if you look at sensitive sectors like defense, apart from the taxation, all the companies which are operating in defense space largely structure their businesses around the IP. And the IP becomes the core strategy for their entire operations in any of the countries, including India. And that would also immediately include licensing structures that they would adopt. So when we talk about this session, which is largely on the monetization, my advice essentially is that structuring, again, I'm repeating myself here, structuring and strategizing should be the first part. You should know exactly what the business is. You should exactly know that what you are looking at from the business. what would be the goodwill that would get generated? Who would own that goodwill? Because we have another example of Indian companies like Flipkart and all, when the companies got acquired by the investors. Now, the important aspect here is that whether you would want to retain the trademark or the IP registration in the name of the entity itself, or would you like to give it to some other entity which would in turn license it? So tomorrow, if the company which is actually in business is taken over by somebody else, you would still retain the IP assets, which can be separately monetized. So these are the things which practically we face, we advise, and we always tell the startups and the people, those who are looking at monetization, that you should keep this into consideration from a long-term business sustainability standpoint, and implement them with clear advice from legal practitioners, or maybe from mutual funds or like other investee companies. That's it from my side.
Thank you, Mr. Rahul. Am I audible?
Yes, sir. Yes, sir.
Okay. Thank you so much, because you have given the very insights of the contractual agreements, be it selling outright, assigning, rather we in our IP terms, we call it assignment. And the other one we call the exhaustion of the rights in totality, and then the licensing, of course. Obviously, in IP cases, people prefer licensing rather than assigning. And well, this the both agreements, be it assignment or be it licensing, the agreements got to be drawn in a very scientific fashion. One or two apprehensions which you have, highlighted. Very true. Not only the disclosure becomes a problem, not only at the stage of commercialization, rather they should not hide. It is for protection. Once they come for protection, they do not protect. Many of them do not protect because of the fear of being disclosed. So, Government of India particularly, in the year 2016, May 2016, came out with IPR policy. And you must be all aware that it had 7 objectives. The 5th objective thereof was for commercialization of IP assets. And they have rather established an organization, CPAM by name, Cell for Intellectual Property Promotion and Management. And that was made responsible for executing the commercialization aspect, the making awareness aspect, and they are doing tremendous job since their inception. And for monetization, like you have talked about the taxation aspect, the Government of India has introduced rather a change income tax law to give the benefit for the royalties which you so get through commercialization. You will be certainly getting some royalty on your works, on your patents, on your IP assets. So the amount of the tune of 3 lakhs on the royalty under 80 RRB, if I'm correctly quoting the section, 18 RRB and 15 FFB. These 2 sections of IT Act were changed to give the benefits of income tax to the royalty earners. So they should be educated. People like you are expected to spread these things to remove the fear from the mind of people that, look, if you do not disclose, still you will have to pay the on whole. So better thing is to do rightful business and then get the rewards which the government is so giving. So on both accounts, the Government of India has made the policy for the first time ever. Though the patenting system was existing in India since 1856, but first time ever in 2016 we had established a formulated IP policy in which there was a specific objective. 5th objective of the national IPR policy is commercialization of IP assets, and very correctly they are implementing it also. The second aspect of it is from where it is created, that is industries, and that is universities. So you have a better linkage between universities and industries who can exploit these things. The commercialization takes place, the job becomes easier. So in recent past, we have seen that the university industry collaboration in India is also growing faster. And all these things taken together, the commercialization, though we are late starters in this field, we agree, but I think it will take a big jump. The IIT is collaborating with Wipros. You have seen the Indian Institute of Science collaborating with several organizations. Things are moving forward. So let's hope for the best. My one question to Miss Anvesha will be, since you are directly to music industry and film industry, piracy is one of the biggest challenge. So how, I mean, what is your idea to tackle this particular situation of piracy? How we will deal with it in proper fashion?
Definitely, thank you for putting for this question, Dr. Singh. Actually, this is even apart from the music industry that we talk of. This is very predominant within the media industry to say, because I clearly remember as a kid, I have watched a lot of pirated contents. Like you would get CDs, which was basically you recorded those pictures, films, going to the cinema hall and then doing it. But if you actually see the trend, I know there needs to be a stricter law towards it, and majorly apart from law, the implementation aspect becomes very crucial here. But we have actually seen a decline in that to a greater extent. Even there were websites whereby you can download those contents. There were websites were not supposed to. You were downloading those films and all those contents has marginally reduced because the government has taken actions over it. However, to what I understand, yes, the implementation becomes very critical and crucial here, because even with the point of having piracy laws and existence of those laws, the implementation and always a loophole or an aspect which is always which leads to an easy escape for the pirated content to flow into the general public is still there. So there is a need for implementation. There is need whereby we understand there is a law in place. There's a functioning or mechanism has to be developed whereby somebody who breaches the law will come under a purview, and what are the consequences to it. So it has to be for any law, for anything to get implemented, this three-stage needs to be passed through. So it's very important just to not limit ourselves to having a law into place. The implementation and after effect has to be looked into, which is very critical here. But again, I think the awareness has played a very important role within the music industry, within the media production houses, that they are very vigilant that the content doesn't get pirated. Every film that goes into a theater basically can't be leaked further, because now they have a key to it. So the key is basically, the password to that key is basically held by the distributor, authorized distributor of that production house. So there's an entire chain from the movie getting ready to it releasing within the theaters. And there is a proper network of distributor, authorized distributor, with whom we contractually enter into an agreement. And to a larger extent, now the distributors are also held responsible for it, because whosoever has an access to the content, because very well rightly pointed out by Mr. Rahul, was that there has to be a mechanism. Either we are licensing the content or we are assigning a content here. Licensing is a more easy way to go, not easy, basically approachable way to basically ensure that the content is reaching the public. Even those distribution channels are licensing the content, the theoretical license is taken by them, and they are putting those films, PVRs and Cineplex are putting those films there. So a lot of reliability is placed on those distributors also to ensure that the content is not pirated from their end, as well as to those platforms that we are distributing the content to. So the need of the hour, I think, is basically implementation. Even if there's a law, there needs to be an implementation to it. Yes, there is a big amount of awareness. The companies as well as the organization are taking it seriously. That's the reason we see there's a decline in it, but there has to be a situation where this absolutely we shut down this practice, which I think will be a gradual process to come into place. So
Thank you
that's the
so much.
idea. Sure.
And of course, we'll be running out of time. 2 minutes are still there. So my next question to Mr. Andre. Basically, normally it is the tendency of book writers or the writers of authors of the book, when they go for publication, the copyright issue comes into picture, and the publishing houses always wants the whole of the copyright being shared, or the whole of the right shared with them. What should be the best strategy for the young authors that you will be suggesting?
I don't know. That's a very difficult question to answer. I'd say Because there isn't a perfect answer. What you want as an author is you want people to read your book, and also commercially you want all versions of it, you know, to be exploited. So all the assets, you want the audiobook, the ebook, the whatever version they could, and the translation rights and so on. So I would say, as an author, I would focus on, are all versions of my work being offered to as many consumers as possible, rather than looking at any other models. I know there is a lot of popularity for authors to aim to try to hold on to some of the rights themselves and effectively be a self-published author. But I think that for the average author, that is underselling or understating how important sort of professionals and publishing houses with IP rights like divisions are. There are actually very few authors who I think really are able to kind of sort of do that themselves. So I do still think that a publisher is best placed to, for the vast majority of authors, a publisher is best placed to manage their rights on their behalf. Obviously, the author should check and they should work with them, but I would say that would be my advice for almost all authors. Very few can really manage their own IP affairs.
Thank you so much. I think we had a very fruitful dialogue. Hopefully, our listeners must be benefited. That is up to them to say. But we have given, our 1 hour has been utilized properly. So thank you so very much. It was our first meeting, but it didn't appear that is our first meeting. It appeared that we have met earlier, we have discussed earlier, we knew each other earlier. That is something I think we are carrying it forward. What we are taking back from here is a good company of all the knowledgeable people. We'll interact further if you so desire anytime. Thank you so very much. Thank you.
Thank you.
Thank you, everyone. Thank you so much.
I'd like to thank each one of you for being a part of our event and making it such a huge success. Thank you so much. And it was such an insightful session with all of you. Hope to see you very soon and have a great day.
Thank you.
Thank you.
Thank you.
Bye.